Smith, why don't you tell me when we're live?
You're live, Judge.
All right, let's go on the record on cause number. Can you give me the cause? Oh, so this is cause number DC 194598, Terry Weimer versus Khosrow Sadigian. Counsel, make your appearances.
Steve Clark and Matt Altick for the defendants, Sadigian.
Mr. DeBose, you're muted.
Many people desire that I be muted, so apparently I joined them. When I was a law professor, the students gave me a nickname which I didn't appreciate at the time, but I now realize how accurate it was. My last name is DuBose. I was nicknamed Professor Verbose. Anyway, Gene DuBose for the plaintiff.
All right, we're here on defendant's motion for summary judgment. Why don't we go ahead and proceed?
All right, thank you, Your Honor. So I know there was one prior hearing with before you, so I don't want to belabor everything, but since we stepped in as new counsel, we thought it would be helpful at least to have this hearing and to share at least our perspective on the motion. I did file really a couple weeks ago, I believe, that our reply summary of position. I don't know if the court had a chance to look at that or not, but
I have.
Okay, so basically the plaintiffs, all of the pled causes of action are based on events that occurred in 2010. The suit was actually filed in April of 2019. So we have a 9-year, almost a statute of repose situation. But we have a 9-year time lag, and the basis, as I understand the plaintiff's pleadings and evidence to overcome limitations, is that the application of the discovery rule.
Well, is there also fraudulent concealment?
Well, they're talking about fraudulent concealment, but I think the cases that I cited in the reply deal with the fraudulent concealment issue. That's the KPMG case, and also the Cadence versus Cosgrove versus Cade, both Texas Supreme Court cases. So the KPMG case dealt with the a duty to investigate once awareness of the loss, in this case, missing information from a deed. And the Cosgrove case talks about the fact that parties who sign documents are presumed to know its contents and be aware of material admissions. So the issue here ultimately is whether or not the discovery rule can be applied to excuse the filing of these claims 9 years after the fact. And I understand, there were objections filed by former counsel to the summary judgment evidence. We could take the time to go through those, but I think for today's purposes in hearing the motion, I just think that, again, I understand under the cases that application of the discovery rule is usually considered to be a question of fact. But both cases that I cited in our reply address that issue and say that there can be circumstances, and I think this is one of them, where the court can determine as a matter of law that the discovery rule is not going to save the cause of action and limitations control. So if we boil the case down to the essence, we're dealing with all of the underlying facts supporting the plaintiff's causes of action are based on events that occurred back in 2010. One of the arguments that the plaintiff makes is, well, I really didn't know. First of all, he says, well, we signed all these documents. I didn't know what they were, and I only got part of them. And I didn't know about the defrauding, or that this was not a lease purchase agreement until after I received discovery after this lawsuit was filed, the lawsuit that alleges the fraud. You know, I don't see how that can be excused, given the fact that he acknowledges that he did receive some of the documents. He says he didn't get all of them, but he acknowledges that he received some of the documents. And then on the issue of you know, fraud or fraudulent concealment, again, there's a duty of inquiry. If something's amiss, then there's a duty of inquiry to inquire, and you can't wait 9 years to do it, or wait 9 years, file a lawsuit, and then in discovery say that, okay, that's where the discovery rule attaches, and therefore everything's limitations are excused. So I think both cases that we cited in the reply are pretty clear and don't help the plaintiff on that. Now, there was one other case that the plaintiff cited. Bear with me a minute, I'm trying to find it on my screen. That I think that didn't make my brief, but the plaintiff had talked about plaintiff talks about this being an executory contract governed by subchapter D, and he cites the Kimsey versus Bergen case. But there's a Texas Supreme Court case, Johnson versus Wood. It's reported at 157 Southwest 2nd 146, and it was addressed in a bankruptcy court case, which is in Ray Finley case, reported at 138 BR 181. It's a 92 case. But basically, what they say there is, if there was an executory contract, and we would submit, you know, that there hasn't been adequate evidence submitted in either in response to the no evidence or the traditional motion for summary judgments to establish it. And the only way that they can get there is to rely on parole evidence that occurred back in 2010, and also try to say that it doesn't address the fact that you've got the merger integration clauses on the contract documents that were signed. But long story short there, even if there was an executory contract, there has to, for that all that gives them is an equitable right that will ripen into equitable title, provided that the party claiming the executory contract shows full performance under the terms. And whether you talk about the transaction 2010, which started off as a purchase agreement, and I think the evidence pretty much not in dispute that the plaintiff didn't have the requisite funds to make the down payment, and then it got converted to a lease agreement. There's the argument, well, you know, the difference in the money was made up by work that was performed, but the lease agreement that Weimer signed shows that there was on its face that there was a rent reduction that contemplated those repairs being done. It was $200 a month under the lease provision. So there has to be a showing of performance. And even if we take the most recent argument, which is there was some sort of a deal struck at when my client went into the JP court and got an order of eviction, that that they would work out a deal for in exchange for the payment of $2,500 and you could keep the property. There's no evidence showing that Weimer ever even performed those terms. So at the end of the day, we have a claim for executory relief that is contradicted by a document they did receive and signed. And I think we attached that to our summary of reply. There was a deed in lieu of foreclosure that was signed back in May of 2010 by the plaintiffs, and attached to that, which is our Exhibit A, was an agreement in case of foreclosure, which they signed, which said basically, if we don't make our payments, we ask that you use the deed in lieu of foreclosure if we're late over 45 days. It's handwritten, it's signed. So I think to kind of summarize, the documents themselves that were signed back in 2010, at a minimum, put if there was missing documentation, missing information, there was enough there to create a duty of inquiry because he's presumed to know what he signed. He had copies, he acknowledges he had copies of most of the documents. There were some that he said he didn't get until discovery, but the reality is, if he signed all those back in 2010, then and he was aware he didn't get them all back in 2010, that's when it starts as far as a duty of inquiry, and we can't stretch it out 9 years. So I think given the fact that we have an executed deed in lieu of foreclosure that the plaintiff signed, and at best they have an executory contract with no evidence that they fully performed its terms, we would, because I'm speaking now to the summary judgment portion on the declaratory judgment action, which plaintiff was attacking, saying it was improper, but we've got a conflicting claims to title, and our written title would prevail over this executory contract with no evidence of performance by the plaintiff. So I think at the end of the day, when you apply the duty of inquiry on the limitations issue, you apply the parole evidence rule, which he has to overcome in order to show this executory agreement, and you look at the conflicts in the title and the fact that they signed a deed in lieu of foreclosure and wrote in and signed and initialed the information, saying that if we want you to proceed with this if we're late in our payments over 45 days. I think at the end of the day, they have met their burden under the no evidence motion, but more importantly, I think under our traditional motion, we've met our burden to establish our legal defense of limitations to all their causes of action. And for that reason, we think summary judgment should be granted, dismissing all the claims. Thank you.
Response?
Thank you, Your Honor. With respect, they seem to be focusing on the statute of limitations, which I think is not an issue, not a sound issue to rely upon. They have, and they've listed a number in their motions, a number of issues where facts are not there are no facts of that, and they have not raised those now. So I assume that they are not pressing that there is evidence of fraud. There is evidence that puts it into.
I think they're just not moving on that. I think they're moving on the statute of limitations argument.
Yeah,
So
that's what I'm hearing.
let's just focus on the statute of limitations.
Okay. Well, with respect to that, my clients, and I think there's not only testimony of my client, but testimony of the expert witness who talked to him, never bought a house, didn't know what the pieces of paper were. And I have another case that I have a $400,000 judgment against Mr. Siddiqui, exactly the same. Comes in, not to an office, but to a restaurant with a stack of papers with people who are ignorant of all processes and says, you need to sign all these, which is exactly Mr. Weimer's testimony. No idea what those things mean. The expert witness says, if you signed the fact that he signed a deed in lieu of foreclosure at the time when he was signing all those papers is evidence of the fact that he did not know what he was doing.
So yeah, it's a little unclear to me. So the deed in lieu of foreclosure was signed when he allegedly purchased the property or signed the original paperwork. It's not at some point in the future.
No, he only met with Mr. Siddiqian once. Mr. Siddiqian says, hey, we came back a couple days later. His testimony is that didn't happen. But Mr. Siddiqian provided him his story, and again, exactly the same story I have in my other case. Mr. Siddiqian says, I'm going to accept your work in lieu of your payment of a down payment. He received some money in down payment, never gave it back to him when he said, oh, this is all canceled a couple of days later. And he gave him certain pieces of paper that absolutely nothing in them contradicted any of his oral statements. The most important thing that he didn't give him was the note that Mr. Weimer and his wife signed. The expert witness says this is designed to fail because it requires him to pay an extra $8,000 2 months into the note, paid all off in 2 years. And had he seen that, he would have known that there was a scam, that he was not being sold the house, because the documents he signed are documents that the expert said were designed to fail. And the way the failure works with Mr. Siddiqian, and I've seen this in several cases, he doesn't tell them that he's in arrears on all these huge payments that are out there that the party doesn't know he owes. And then later, when he goes, for example, to evict him, as he did here, he would say, you're $19,000 in arrears. And he said, where's the $19,000? So it's true that he
Can you give me a little more of a chronology here? So in 2010, they have this meeting at the restaurant.
Yes.
And some of the documents are later provided, some of them aren't. And then he continues he fixes up the house, correct?
Yes, he does.
Your client fixes up the house, and then he makes payments on the house as well until what year?
Well, there was a period that he didn't pay, and then he picked up paying again, simply because Mr. Siddiqian raised the rent, and my guy could pay a little bit, and then he just couldn't pay, which led to the eviction. And at the eviction, again, Mr. Siddiqian got him off to the side after the hearing and said, we're not, if you do this deal with us, pay me this money, then, you can stay in the houses. Significantly, he didn't make that offer until he actually met my client at the house. So the house was in pretty good condition. But the reason he did that is had Mr. Siddiqian, had Mr. Weimer mentioned to the judge that he was buying the house, instantly that judge at the eviction court would have said, there's an issue of title here. I can't, I have no jurisdiction to give this this eviction order.
When was this foreclosure hearing, or when was this eviction hearing?
It was about 3 or 4 weeks before the case was filed, because I happened onto Mr. Weimer. I was looking for houses around that Sadigian owned to see what shape they were in, things like that, figuring that I would have to execute on him. I knocked on his door and met him, and we talked. And in the process of talking to me, he said, I'm getting evicted out of this house right away. And it was a case so similar to the one that I'd already had.
And your client believed he was buying the house, correct?
He still believed he was buying the house. And when Mr. Sadigian came to him again before, apparently they had signed a judgment of, agreed to a judgment of eviction. But Mr. Sadigian then goes, well, if you do this deal, then I will keep you in the house. So he thought the deal was still going at that time. And that really bears upon concealment of the issue. Didn't give him any pieces of paper whereby he would have seen from what he'd signed that he was, that Mr. Sadigian was not intending to sell. Because remember, you have to be aware of the elements of the claim. The essential element of a false promise claim is that the party, when he made that promise, had no intention of keeping it. And this is one of those rare cases where you actually have pieces of paper signed by the defrauder, which prove that he did not intend to sell the house. If you were intending to sell the house, you would not have a note that's drafted like that. So it is many years later, but that's not the point. The point is that he didn't know the elements of his claim. And the reason why that went into the pleadings is I was sure, because I've been around Mr. Sadigian for a while, I was sure that it was one of those deals, just like my other case, where he never actually intended to sell the case. Now, my guy was not aware of that until he actually saw the pieces of paper. And it floored him, surprised him. He's a smart guy, but he's not sophisticated at all in real estate. So I don't think that the statute of limitations argument works, because there was fraudulent concealment. And again, the action doesn't accrue until the plaintiff becomes aware of the facts that show the fraud. And he wasn't aware of that till he saw these pieces of paper. And we did some very fast discovery, expedited discovery, because I filed and got a TRO. And then he saw that. And then it was sort of like the scales fell from his eyes. Mr. Sadigian, when you deal with him person to person, he sounds like, he's just the sweetest guy in the world. All he wants to do is do a deal with you. And he is absolutely the worst human being I have ever met. I have 3 cases against him. And he's a bad dude. But in any case, in terms of the statute of limitations, the arguments aren't there. They're disputed facts. Mr. Sadigian is, I'm sure, going to say I didn't make that offer to him. And when you have disputed facts, you can't grant a summary judgment.
Okay, Mr. Clark, response?
Yeah, well, besides attacking my client's character, I really haven't heard anything from the plaintiff to show a justification to wait 9 years. He talked about not receiving the note, but one of the pieces of evidence that they attached to their own motions was the financing statement, which gives all these elements. But, you know, again, and my client testified at the injunction hearing in terms of what the understanding was of the parties at the time all these documents were executed. But the bottom line is there were enough documents executed. You look at the lease agreement itself, and it clearly shows that that the initial rent had been adjusted.
I guess what's so confusing to me, I'm sorry, there's some kind of background noise. I guess what's kind of confusing to me is, so he had him sign a deed in lieu of foreclosure, but he said it was a rental property that he was just renting to them.
So what happened was the original transaction was supposed to be a sale of the property. But when they got down to closing the deal, he didn't have the money for the down payment. So it got converted to a lease. And there was a written lease agreement executed at that time. And for several years, he made payments on the lease. The court asked the question, which was a good one, is, you know, when did he stop making payments? And that was back in like 2014 that he stopped making payments on it. So, but the real issue is, if this was an executory contract to, you know, for a lease purchase agreement, then when is he on a duty of inquiry as it relates to documents that he signed? And that's also, you know, has to dovetail into what his actual performance was. And he treated it as a lease transaction. And the only way that he can get it out from under that is to rely on parole evidence of what Mr. Sadakian purportedly told him back in 2010. So even if you accept everything as true that is, you know, attributed to my client back in 2010, he can't just sit there and say, well, I'm ignorant. I didn't know what I signed. I have most of the documents, but I can remain blissfully ignorant.
It's some of the documents. I'm not sure what's happening there. Some of the documents show that it's a lease, and some of them show that it's a sale, right?
Right. So if he thinks that there's a contradiction, you know, when does that reasonable duty of inquiry start? And it can't wait 9 years until discovery.
So all right. So I'm going to go ahead. This is kind of a mess, the whole thing. So I'm going to go ahead and deny the summary judgment. Mr. DuBose, go ahead and get me an order on that. And make sure on the order that it says that this hearing occurred on March 19th, 2021, and that it denies the summary judgment on all points. Go ahead and email that to my court coordinator, as well as e-file it as well. Okay.
Thank you, Your Honor.
Thank you.
Thank you, guys. Good job. And sounds like an interesting case. One other thing is, you guys are set for trial in October. I don't know if I think Mr. Clark may have been on the call in the previous hearing, but I'll let you know, Mr. DuBose, is that the newest information we've gotten from our local administrative district judge is that we're going to go forward with limited trials in August and then a full trial docket in October. This case is set in October, so, you know, I don't know if you would be reached, but at least as of this moment, it looks like we will be doing jury trials at that time.
Yes.
So let's hope. All right. You guys be safe, and we'll see you soon, okay?
All right.
Thank you, Judge.
Thank you. Make sure you get Mr. DuBose, if you could get that order in today, I'm going to sign it on Monday.
I'll draft it instantly. Right.
All right. And send it to Rhonda, and you file it. Thanks. Bye.
Okay.
Thank you.
Hello, Mr. Henley. How are you?
Good morning, Judge. How are you?
Good.
So I think